All right, hi, welcome back, Attorney Steve Honor. Welcome to another exciting video. Today we are talking about motion to withdraw as counsel of record, as we say. This is something that you hope doesn't come up too often in your career, but it does pop up as a lawyer, sometimes as a client. It could pop up. And a lot of the times people say, well, if you run out of money or you just can't afford the lawyer anymore, then the lawyer has a right to terminate the case. And the retainer agreement may say you have the right to terminate a case, but you have to be careful. There are some instances when a court might not let you off, might not relieve you as your duties of counsel. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so again, these are things like sometimes you get in, usually when you retain a client, there's usually something in the retainer agreement that says if you fail to make the payments, I may fail to perform the services and seek to withdraw as legal counsel. In a state court, I'm just going to take California, for example. It can be as simple as just filing a form, like a judicial consent form. Judicial counsel form, rather. So it could be simple as, hey, have your client sign it, the new attorney signs it, and you file it with the court. Court says, hey, sounds good to me. You guys all agreed? Good to me. And check your state. This is not legal advice, is general legal information only, but check your state. You may have something similar. However, when you get into federal court, I have found, actually having been in federal court over a couple hundred times, that it's a little more rigorous if you need to get off the case. So it's very important. Let's talk about some of these. Usually you're going to have to file MTW, a motion to withdraw. A motion's really just where you're asking the court to do something. And so even though your client may consent, even though the bills may not be paid, you still have to file a formal notice of a motion to withdraw as counsel with your memorandums of points and authorities. And I'll just tell you real quick, there's usually two different things. Mandatory grounds for withdrawal. Let's say your client's asking you to commit a fraud, okay? If the client's asking you to do that, the court's going to say, okay, it's mandatory grounds for withdrawal or a conflict of interest, things like that. Otherwise, it's usually permissive. In most cases, I will say, check your rules on that, by the way. Usually it is permissive, which is what we call left at the sound discretion of the court, left to the sound discretion of the judge. Okay, so this is where you got to make the case, you've got to persuade, you've got to show the good cause. You also need to show that, here's your client, here's my beautiful picture. I should have been an artist of some sort, don't you think? Maybe I can. Maybe some of my beeps on here can turn this into an NFT for me. Anyway, but anyway, with your client, as you're departing, you have some obligations to your client. Keep them informed of where you're at on the case, any case deadlines, any outstanding discovery that's due. Give them a copy of their case file, those sorts of things. And also let them know, like, for example, in a corporation, you cannot represent yourself in court. So if your client's a corporation, you need to advise them you cannot represent yourself in a court. If you try that, you could be defaulted, so forth and so on. But let them know the risks of going improper. And I'll just tell you, generally speaking, the courts, even if you're improper or pro se, as we call it sometimes, you're still going to be obligated to follow the rules. In federal court, you're still going to be obligated to follow the federal rules of civil procedure. So just because you're pro se and pro per doesn't mean that you get a free pass just to do whatever you want to do in court. So giving those disclosures to your client of the proper risks, what's going on, and also that they can pick up their file. Basic things like this. And so you file the motion, you tell your judge what's going on. Maybe the client breached the retainer agreement. Maybe they're persisting on creating adversarial problems with the attorney. They just can't work together anymore. Maybe the client has abandoned the attorney and is not responding. So there's lots of different grounds for permissive withdrawal. But set those forward. Don't take it for granted that you're just going to be allowed off the case. Do your formal notice, set up a hearing, set up a motion, and also talk to the opposing counsel about it. Let them know what you're going to do, see if they have any objections. Sometimes you're going to find that you go to court and they're going to object for some odd reason. Maybe they have a pending motion and they're actually going to object. So find out in advance, talk to your client, talk to the counsel, document your efforts, notice. Notice the motion points and authorities. A declaration. So a declaration of due diligence. What does that mean, Attorney Steve? Well, just you're going to tell the court, I've done these things. I've talked to my client. I've given certain disclosures. And check your local rules. You may have certain disclosures that you need to give, and check your judge's standing orders. See if there's special rules you have to give your client, okay? So a declaration of due diligence. Here's what I did, Judge. Ho, ho. And the proposed order saying that I am seeking relief to be relieved as counsel as of a certain date. So these are your 4 documents that you want to do. Never forget, in federal court, do you need a chambers copy? Sometimes you forget that. See if the court, sometimes a federal court will want a chambers copy. Sometimes it's just email the clerk, get the clerk the proposed order. So check your rules on that. Make sure you're following those rules. You want to serve all the other parties to the case, your motion, and this, that, and the other. And the times I have up here, okay, is when you may not be granted the motion is if you're causing prejudice to the other party. And so be prepared that this argument could come up. Well, I'm not going to let you off the case right now, counsel, because we have a motion pending. Or here's another one. If you get too close to a trial date, trial's coming up in 2 weeks, and now you want to get off as counsel, you could run into some problems, okay? So just be thinking about all this. But that's the general nuts and bolts of a motion to withdraw as legal counsel. Again, check your local rules, see how it is. But that's a general overview. So there is a bigger process involved. Usually as an attorney, you want to make sure you've got a good client, that you're not going to have to do this in 2 months into the case, okay? So I hope this has been helpful. Attorney Steve Vonder, and you know it, where to find us if you need help. Civil litigation, intellectual property law, you know where to find us. On the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Thanks for watching. I got to run. Got a busy day today. Take care. We'll talk again. Bye now.